And welcome to the afternoon constitutional. Thank you so much for letting us be of service to you this morning, this afternoon. Pardon me. Old habits die hard, and you can certainly hook up with us here through our phones at 434-964-1075. It's the only one of these kind of programs that takes listener phone calls as well. Joining us from, and the reason we opened with the homage to our Supreme Court justices with the great Sammy Davis Jr. from the old Laugh-In program is because just earlier today, the Supreme Court announced that they are going to hear a case involving a bunch of fishermen who are looking for the right to, I don't know, crazy stuff, fish. And it may actually lead to the overturning of something perhaps even more seminal. This will be controversial to you than Roe versus Wade. It is a ruling from 1994 that pretty much the U.S. government has been hiding behind ever since. It's called the Chevron ruling. And the Chevron ruling says basically, and I've got a bunch of folks who are going to explain it better for us, that where legislation is vague, the bureaucracies can fill in the blanks. And so what that's led to are Congress people writing vague regulations and then allowing groups like the EPA or the FDA to kind of fill in the gaps there. Joining us to kick off our coverage of it, and we're actually going to speak to one of the folks who is a participant in the case a little bit later on, is Devin Watkins from the Competitive Enterprise.
I can't hear you still.
Devin, how are you doing, sir? Devin Watkins. I'm sorry about that, folks. But let me go back and reset here a little bit. Why Sammy Davis Jr. brought us in here, but we have the Supreme Court ruling that they are going to hear a case that has been brought by a group of fishermen. If you didn't read lips before, then this is what we were telling you. That's not you, Devin, everyone else, because apparently my mic was off for everybody. But these fishermen have brought a case saying, hey, we'd like to go fishing. And there's regulation that's in their way from doing it. And they say that there's no legal authority for the government to stop them, but there's this ruling called Chevron. The Chevron case from 1994 basically says where legislation is vague, then the bureaucracies get to fill in the blanks on it. Devin Watkins is joining us from the Competitive Enterprise Institute to start us off this morning, Devin, and happy Monday. Thank you for taking some time out. I'm sure I was very casual in my depiction of the Chevron ruling. Let's go into that one first from 1994, and then we'll talk about how these guys may overturn it.
Sure. So the case in 1994, it's 1984. It's rather complex topic because it deals with some very detailed statutory interpretation questions that aren't as relevant to some of the broader principles that are at stake. But the real question is, one, has Congress given the agency the authority to issue these rules? Mm-hmm. Some agencies have this authority, some don't. And so that's kind of the first question that's before the court. Has Congress actually stepped forward to give the agency this authority? Second question is the statute ambiguous? Because if the statute is unambiguous and clear as to what it means, then an agency doesn't have any authority to override what the statute says. But within the scope of what it's ambiguous, the courts allowed the agency to kind of pick among many possible reasonable interpretations of what the statute meant.
So is that, and this is where I feel like many of our viewers certainly feel like some of these regulatory agencies in the federal government have overstepped, where then they point back to the legislation that established whatever program it is and said, no, it's right here. And they've used Chevron quite frequently as a get-out-of-jail-free card regarding actually having congressional authority to restrict somebody's right to farm or fish or anything like that, correct?
Yes. So, just about any statute, if you look at it hard enough or ask a narrow enough question, you can see a little bit of ambiguity around the edges as to exactly which meaning of which words were available.
Hmm.
And the agencies use this to the nth degree. They know that is where their power lies. So they're going to do everything in their power to argue that there is everything is ambiguous. And then because everything's ambiguous, they get to decide what all the rules are.
Well, it does this also, and I feel this has also established a situation where Congress, in an effort to look good behind a podium and say, "I'm going to clean up the Chesapeake Bay," writes a bill that just says we're going to give one. Pick a number, trillions, or have we used up trillions yet? We'll give $1 billion to the EPA to clean up the Chesapeake Bay by 2020, and then the EPA gets to kind of fill in the blanks as to how they're going to do it. So it's also created lazy representation on behalf of our congressional representative, hasn't it, Devin?
Yes, but I should note that this doesn't usually come into play for appropriations. If they give money to the agency to go do something, that kind of falls in a different area of law. Most of the time, what this is regulations. So what's going to happen then is there's a rule that comes out that say in the Chesapeake Bay you can't put anything in the Chesapeake Bay, even dirt, not allowed.
Hmm.
And
And if
that
you
of
have
course
runoff, you're going to be sued for the runoff.
Exactly.
Yeah.
Anything goes into the bay because of your actions, they're going to come after you for. And this can be a very oppressive kind of regulation that causes enormous side effects. But the Congress can say, "I just told them to go clean the bay. It's not my fault. I
Yeah.
just said go do good things. If you want to complain about that, go talk to them." So it basically has been used by some congressmen to say, "I'm just voting to go do good things. If you want to complain about the details, go talk to the other guy." And it allows them to avoid a lot of the costs that are in these regulations because there's always going to be trade-offs between one group or another group, and this allows Congress to often avoid those trade-offs.
So how frequently, and it's been portrayed in different ways. Devin Watkins is on from the Competitive Enterprise Institute with us. How many different ways over the past, so it sounds like 40 years since the ruling, has it been demagogued into either a defense of the indefensible by a bureaucrat or by a Congress critter who wants to just seem like they're doing good things, but at the end of the day, they're actually killing jobs, taking people's property freedoms away, and that kind of thing.
So it's been very often in Congress that they have been using these kind of delegations to pass laws that basically say go do good things without taking responsibility for those actions. In the courts, it started out somewhat reasonable, but then very quickly expanded to be almost and the agency can do whatever it wants. It was really quite expansive in the deference that was given to the agency to interpret statutes. More lately, the courts have been pulling back on that deference, especially the Supreme Court. During the last 4 or 5 years, the Supreme Court has basically not cited Chevron at all in any cases.
Hmm.
Even in cases that were decided on the basis of Chevron in the lower courts, the Supreme Court has pretended that Chevron doesn't exist because they've so realized the problems at Chevron. They haven't taken the step of actually overruling Chevron and telling the lower courts to stop using it. So in the Supreme Court, there's almost no Chevron that even
Hmm.
occurs anymore. Even the government doesn't even try to defend their regulations on the basis of Chevron in the Supreme Court. But in the lower courts, Chevron is used all the time and is often the basis upon which lower courts rule in favor of the government.
And just give us a little primer, Devin, as to the specifics of the Chevron ruling, because so often we see, for example, Roe was a medical privacy ruling, really, or at least as it was argued. What were the case points in the Chevron ruling that gets so frequently noted in these lower courts and up until recently at the Supreme Court?
So they were trying. they were trying to go around different fence line regulations and kind of what the bubble of allowed rules
Mm.
were. I can go into a lot of the detail, but it's going to be quite a drag on. It's a lot of detail that isn't that applicable to a lot of other cases. I know that we have other cases right now where we're challenging under the auto emission rules that just came out under
Hmm.
EPA. And for instance, in our case, they have averaging, where they're averaging the amount of emissions,
Right.
even though the Clean Air Act doesn't say anything like that whatsoever. That's the kind
Ah.
of thing that would have come in under Chevron. But now I think even the government realizes they can't get away with Chevron anymore, that it's kind of got the death knell behind it, that if they try to rely on it, they're going to get shut down more and more often. So they're kind of moving away from that and trying to
Hmm.
defend it right
With.
on the statute. But those are the kind of issues where it's close, it's kind of very detailed
Hmm.
questions as to how what it means by different words in the statute
Hmm.
that the original decision was based on.
Well, I know that after EPA versus West Virginia, for example, we started to feel like, oh, this is the Supreme Court is trying to rein in this regulatory state. Is this a next step in this? Is this something that was identified after West Virginia versus EPA, Devin?
So West Virginia v. EPA, it named the major questions doctrine
Hmm.
that basically say if the agency is making a decision that has major implications, either politically or economically, or it's going to vastly expand the agency's power, that's not something that we should just defer to the agency on. That's something we need clear congressional authorization for. And so, yeah, that cut back on Chevron quite a bit within the scope of cases that actually hit the major questions doctrine. But that's what most of the fight is about these days. Is this case a major questions doctrine case or is it not? Our EPA case, for instance, was the largest, most expensive rule that has ever been issued by any agency, having $300 billion in costs, and the
Mm.
government said it's not
Wow.
a major rule. That shouldn't be fall within the major questions doctrine. That's the kind of fights we're having right now. And the possibility here in Loper Bright, the case that was just granted, could eliminate all of the Chevron deference entirely and just go back to the statute itself without deference, or it could give a lower level of deference called Skidmore deference that basically says if this interpretation of the law has been long standing by both parties over time and everyone kind of agreed about it for a long time, and now you want to come in and change it, maybe we'll give a little bit of deference to the agency in that case. But generally, we're not going to just defer to the agency on new interpretations or controversial interpretations.
So let me ask you, and we saw this, and of course, this program is sponsored by the Government Accountability and Oversight Group, govoversight.org, and I know that one of our fellows has for many years worked with Competitive Enterprise Institute, a fellow named Chris Horner, and famous the case of Lisa Jackson and her phony email accounts that she was writing to people and working with agencies with one particular standpoint or another in those regulatory. So I'm looking a level down in here. Does this rein in the power of these agencies to sort of start working in the shadows, metaphorically in the parking garage, talking to interested parties when it comes to some of this regulation?
So, to a certain extent, it does, um, in that it lowers the scope of what the agency can decide itself, and therefore lowers the amount of power those agencies have. But to a certain extent, not so much.
Hmm.
So the agency can still interpret the statute and say, we think the statute means A. The only difference would be the judges wouldn't defer to the agency saying it means A. The judges would have to independently make their own evaluation of the statute to see if they believe it means A. So much of what the agencies can do today, they can still potentially do, but there's a judicial check to prevent them from abusing their authority.
Well, and I guess that's where it's become imperative, and there's a I the process is the punishment angle to this as well, isn't it? Isn't there, Devin? We're on with Devin Watkins from the Competitive Enterprise Institute, where the regulatory agency does something, and then it costs quite a bit of money to fight it all the way up through the Supreme Court, doesn't it?
Oh, it costs like $1 million. If you're going all the way to the Supreme Court, expect it to take it cost $1 million. Now, the place I work, we represent people pro bono, so we
Hmm.
don't charge anyone for the people we represent. But if you're going to a private person and you're going to fight it all the way through the district court, you're going to appeal it, fight it all the way through the circuit court, and then you're going to fight it at the Supreme Court. And that assumes we're not going through like agency adjudication where you have administrative law
Oh my gosh.
judges and
Yeah.
internal adjudication processes in the agency. All of these things add costs to be able to fight it all the way up. And most people just don't have the funds to be able to fight the agency all the way up to the Supreme Court. And when you know that the agency is going to have a giant thumb on their side of the scale,
Hmm.
that reduces the amount of cases that people are going to challenge. Why do I want to go into court and try to challenge it where my odds of success are like 10%, even if I'm right?
Right.
If the odds are so low that I'm going to be successful in my legal challenge, people are just not going to bring it.
So, take us in the little bit that we know about this New Jersey fisherman's case, and this is the case that the Supreme Court agreed to hear today. Just announced this morning that they're going to hear the case. Now, certainly, it seems like the court is balanced in favor of people that would rule against the agencies and the regulatory capture. But folks like John Roberts and Neil Gorsuch have been fungible on cases like this, haven't they, Devin?
They have at times, but let me talk about this case.
Yeah.
Uh, the Competitive Enterprise Institute filed a brief in this case asking the Supreme Court to take this case. And what this
Good
case
for you.
has,
Thank you.
thank you. What this case has to do with is certain fishing plans. So this Congress had recognized that the United States has some ownership or property over the fishing areas right off the coast of the United States. And so what they did is they authorized the agency to issue fishing plans to kind of regulate and decide how fishing is going to be done so that we don't overfish these areas and basically eat up all the fish so that there's no
Hmm.
new baby fish being born and destroy the fish industry.
Hmm.
And so they basically just said, go issue these fishing plans. Well, the agency, having not gotten enough money from Congress to do what they wanted to do to ensure that all of the fishermen were actually complying with the fishing plans they had enacted, decided to add a new rule to their fishing plans. And their new rule was going to require the fishermen to pay for government monitors that would be
Oh my
going
God.
onto their fishing vessels to watch them and make sure that they are actually complying with the rules.
that's that's a whole new level of loser pays, Devin.
Yeah.
I imagine then you were pleased that the Supreme Court agreed to hear the case today.
Oh, absolutely. What's really nasty in this case is that Congress had never authorized this. There was not one word in the statute saying that the agency could do this. And the lower court recognized that there was not one word in the statute authorizing the agency to do this. But they still allowed the agency to do it anyway, because they said that the silence in the statute was enough to authorize the agency to go enact the rule. So, where Congress hasn't specifically told the agency they can't do something, then the agency can go and do it. And that is so abusive and so over the top of what it does. And think about what this is. This is effectively a tax increase. This is more money being spent, given to the government appointed people to make sure the laws are being followed, that was never decided by the people's
Hmm.
representatives. And so we came in and asked the court to take this case because of how extremely abusive that was to the separation of powers. These decisions are supposed to be made by Congress. And if Congress has not decided to authorize the agency to do this, then it can't do it.
What do you expect the possibility of precedent in this ruling? Obviously, there's always the dissenting opinion that somebody might write that could lead to future cases, but also what do you expect the ramifications if all goes kind of the way we see the Supreme Court lately, especially in the light of EPA and Dobbs and some of the other ones being very conservative leaning? What are your hopes? What's the best case scenario? And what's somebody who's done this a few times? Your expectations, Devin.
So there are four possibilities from the way that I see it as to how the court might go forward in this case. One is to affirm the lower court. Just say the lower court was right. They did the good job. Good job, lower court. I think this is unlikely. The court could have denied cert, that is, asking
Hmm.
the court to take the case. And if they thought the lower court was doing a good job, they just would have denied cert. There would have been no
Yeah.
reason for the court to have taken this case. The second thing they could do is they could not overrule Chevron, but they could never narrow Chevron. They could say that silence isn't enough for the agency to enact rules to say what that silence means. This would narrow the scope of Chevron, but still allow Chevron to exist for interpreting the words of the statutes that Congress
Hmm.
enacted. The third thing that they could do is they could overrule Chevron and say, we're getting rid of Chevron, but we're going back to Skidmore deference. So the agencies still get deference, but rather than the agency's opinion of what the statute means being binding on the court, so the court is forced to accept the agency's interpretation, the interpretation of the agency may be persuasive or
Hmm.
long-standing interpretations that are uncontroversial and everyone kind of agrees as what the statute means. Those kind of things could influence the court's interpretation of what the statute means, but not be binding on the court. The court would still have a responsibility to say what it thinks the statute means, and that's what would control. And lastly, it could overturn Chevron, but not go back to Chevron deference and just say the agency gets no deference. It is the court's job to say what the law means and interpret the statutes.
So, and let me go in a little bit to what our listeners and viewers might expect from something like this. It sounds like it could be very narrowly focused, so it's not going to rein in an EPA going after a farmer for a creek that has water in it 3 months out of the year as a protected wetland or anything like that. But it could put that arrow in somebody's quiver, couldn't it, Devin?
So, on the very narrow interpretation on silence, I suspect that most things that the government does, it'll still be able to keep doing.
Hmm.
This was a really radical kind of interpretation of the underlying statute to say, yeah, the statute doesn't even mention this, but we'll create it out of whole cloth.
Hmm.
That kind of argument is actually quite rare by the government. And so I think if the decision is that narrow, although it does limit Chevron and puts an additional quiver in some people's some litigation that might be able to use that, I think the vast majority of rules it won't be impacted by that. If it actually overturns Chevron, it's going to be a new day. I mean,
Hmm.
there's going to be substantial changes throughout the federal regulatory system in all kinds of different ways.
Well, and the last thought for this, certainly you know how much this regulatory leviathan, eats up in terms of the volumes of regulations that come out of hundreds of volumes of law becomes tens of thousands of volumes of regulation. Even there some way to narrow how much of that can happen, Devin?
Well, I mean, Congress obviously could step in and do that. We're actually going to be proposing a change that would take away all the rulemaking power from the agencies and put it back within Congress's hands to enact.
Hmm.
But there's lots of things Congress could do. There's lots of things the president can do if he wants to step in and limit the agency. But without Congress or the president stepping in, there's not likely to be any much limitation unless the courts overrule Chevron.
I just got an email from a listener who said, hold it, fishing in New Jersey? People still fish in New Jersey? So I guess there's some novelty to that. Devin, thank you so much for your time at the Competitive Enterprise Institute. Support them. You heard him say, they do this pro bono when they take these cases, CEI.org. Thank you, sir, and you have a great afternoon.
Thanks, you. Bye.
434-964-1075 is our number. And, of course, you can email us as well, joe@wchv.com, which is also available for you at any time through that as well. Now, we're going to visit with one of the folks particular to this case, and he's with Cause of Action. Ryan Mulvey is going to join us in just a little bit to talk about this. But when you talk about where we are and where we have been nationally regarding the regulatory capture that we've seen and the situations where family farmers and this kind of thing really get crushed under these onerous regulations, this could be, as Devin, very carefully, lawyers aren't one towards, well, I should say some lawyers are very cautious about wild prognostications and punditry. Other ones, they get kind of comfortable with it and usually wind up with some former president in court with them. But this is something that, as I said, and I don't mean to be dismissive about Dobbs, but this is the kind of ruling that could quite easily be, a seminal moment for the Supreme Court in terms of reining in this regulatory capture, the ability of the unelected, anonymous bureaucrats to come along and say, yeah, we were told to, clean up the Chesapeake Bay, and I'm picking on the Chesapeake Bay because, well, Virginia. But we think we need to do this to you, and therefore we're going to create this law that's going to punish you and shut you down as well. On that subject, though, there is a small subtext that goes on regarding the Supreme Court and the Dobbs ruling while we're waiting for Mr. Mulvey to join us on set is the release that they will not and could not determine which person within the Supreme Court leaked the Dobbs decision earlier. I think it was Justice Kavanaugh said that he had a pretty good idea who it was, but not to the level of evidence to enter in a court of law. So whoever it was obviously was adept enough at covering their tracks to not leave enough breadcrumbs to cause anyone to figure them out and out them. But as some of the Supreme Court justices have said, we pretty well know who it was. And it was designed to create the furor over the Dobbs decision that it did. Mission accomplished there, to start the public outcry and the hue and cry about the Dobbs decision that we saw transpire, and they will. I don't know if this person still has access to these documents or not, but they certainly have been caught internally. And I've pointed out, I find it interesting that we can find one person who's released classified documents from 1 million reservists across the country, but a subset of about 10 to 15 people, was what I was told, are about the only people with the kind of security clearance at the Supreme Court that could have had access to the Dobbs ruling beforehand to have leaked it to the press. And you can take that for what it's worth. I know several of the Supreme Court justices had said that they felt that their lives became immediately in danger when that happened. But again, as I think it was Kavanaugh said, we really don't have the kind of case that we could walk into a courtroom with. Now, speaking of walking into a courtroom, he is one of the participants in a degree in providing advice and counsel to the fishermen in question. He is Ryan Mulvey, and he is with Cause of Action. Ryan, thank you for joining us on the Afternoon Constitutional. How are you doing, sir?
I'm well. Thank you so much for the invitation. Happy to be here.
And it was, I thought it was interesting. One of our listeners just a few moments ago, we were talking about it, said, "Hold it, there are fishermen in New Jersey." I guess so. There's a hit for their tourism industry. That yes, we still have agriculture in New Jersey. It's not all the lyrics of a Bruce Springsteen song after all. So get us into some of the details about what happened to these fishermen that brings it to this point where the Supreme Court has agreed to hear the case.
Yeah, absolutely. So the name of our case is Loper Bright Enterprises versus Raimondo. And to back up, where it starts with is a regulation called the New England Industry Funded Monitoring Omnibus Amendment. And
A mouthful.
Yes, it's quite a mouthful. The Omnibus Amendment is what it's called for short. And fishing regulation is a very interesting and complex area of law in that the government has set up these special councils that have state, federal, and non-government folks, stakeholders, all represented, and they kind of come up with ideas for how to manage the fisheries, and then the government implements those rules. And the New England fishery, which has jurisdiction over herring, and our clients, they what's relevant here is they fish for herring. They're in New Jersey, but the herring fishery goes all the way up to the Canadian border.
Okay.
And the Management Council and the agency, National Marine Fisheries Service, wanted to have more monitoring of what the fishermen are doing. So it's a totally discretionary program. And the council and the government realized that they couldn't pay for it. They didn't have the money. So they decided to come up with something called the industry funding requirement, where they said, we're just going to order the regulated fishermen to pay for it.
Unbelievable.
So, yeah, unbelievable. It's not only did they order them to carry the monitors, which the statute, the law here does permit that. So the fishermen already have to endure carrying the monitor, but without any authorization in the statute, the government decided, well, we can't pay for it. Congress won't give us the money. We don't want to go to the ask for it. So we're just going to impose this by fiat. And so when they did that, the agency, the government itself, predicted that the costs were likely to be around $710 a day.
Oh my gosh.
And that's
a lot of herring.
It's right, and that it's going to reduce the fishermen's revenue by 20%. Now, in the interim, keep in mind too that the agency decided to cut herring quota by unprecedented levels. So you have here like a perfect storm, if you will, where a substantial portion of the fleet was going to face could have faced economic devastation, and all because the agency just wants to have more monitoring. So this lawsuit is, our attempt to try to put a stop to that.
So was there a problem of fishermen? Because I as I was looking at this seems to be another one of these regulations that say, well, if we don't stop these fishermen, they're going to fish every herring out of the sea, and then there's going to be no herring at all ever again, which just, it's the same silliness that they talked about logging companies saying, well, why would a logging company clear cut something and then not have any logs left? Why wouldn't they, do that under their own best interest? Is that what was going on here?
Yeah. Well, it's interesting you say that, because some of the best conservationists, for example, are hunters and fishermen, because they don't want the resource to be depleted.
Exactly.
And there is definitely in the background here a lot of contest over the science of the fishery and just how healthy the resource is doing. And I think a lot of fishermen think that the fishery is not doing so bad. And more to the point, herring is a very clean fishery. So a lot of the monitoring that takes place in
Did we lose?
which
I'm sorry. You broke up there for a second.
did I break
Yeah,
up?
yeah,
Oh,
that's all
sorry.
right.
A lot of the monitoring in domestic fisheries has to do with keeping track of bycatch. So if you say you're going to fish for herring, but then you catch a different type of fish, right?
Mm-hmm.
Well, herring is a very clean fishery, meaning most of what they catch is what they say they're going to catch. And they're pretty good. The fishermen are pretty good about conserving the resource for the
Mm-hmm.
reason that you pointed out. So I think there's a lot of other stuff going in the background here. The agency, part of why this regulation is called the Omnibus Amendment is because the agency also introduced provisions that apply to all the fisheries between
Mm-hmm.
Maine and North Carolina,
Wow.
because they want to introduce. This is not the only fishery that has industry funding. The groundfish fishery in
Mm-hmm.
New England, which if any of you saw the movie Coda, which won the Academy
Oh,
Award,
yeah.
I think last year, that's about the groundfish fishery in New England. And there, the fleet has been killed by this same industry funding requirement. So the agency is looking ahead. It wants to do this same sort of requirement in the other fisheries. So even if herring was an easy target,
Mm-hmm.
they're trying to think ahead, which is all the more reason why
Yeah.
it needs to be checked now.
Well, yeah, nothing like an agency of the federal government thinking ahead of new tactic. So as they drive these industries out, and as a matter of fact, I was talking with Joanne Skousen of the Anthem Film Festival, and the folks who made Coda have a new film that are going to be in the Anthem Film Festival coming this July. What is the end game then? I mean, if you drive out all the fishermen, where are we going to get the herring from? Or is there a Chinese fishery that's making the herring that, somebody's, let's just say somebody's son has a deal with a herring fishery in Ukraine or China or someplace like that? Hypothetically, of course, that might want to deal with them. What is the game if you're going to drive out these fishing vessels or any kind of agriculture?
Wow, that's a good question. If only I could read the minds of the bureaucrats in the federal government who decided that this rule was a good idea.
Mm-hmm.
I think one thing is for certain is that there are consequences that will be if this rule goes, it ends up getting fully implemented and the Supreme Court doesn't rule for the fishermen and put a stop to all of this. There will be unintended and serious consequences beyond the fishery. So, herring is used as lobster bait. So other seafood prices are going to go up.
Mm-hmm.
Herring itself will become more expensive, but there will also be impacts on fishing communities. So, you mentioned commercial fishing in New Jersey. Our clients are based in Cape May, which is the very southern point of the state. And Cape May largely relies on fishing and tourism. So this rule could have a huge impact on local jobs and the local economy. And that's going to be the case with all the fisheries all up and down the eastern seaboard. The agency gave very little consideration to those sorts of costs. And it's also just very sad. I mean, fishing in this part of the country is a legacy institution. I mean, our waters have been fished since the very beginning, even before the country. And to see this industry go under because of over regulation it would be very sad to see that come to pass.
And speak to that. Ryan Mulvey is on with us from Cause of Action, and one of the particulars in this case of the New Jersey fishermen fighting back against the regulation. Because you mentioned, you couldn't read a bureaucrat's mind, but one of the things it'd be interesting to read, and one of the things that we focus on here frequently is transparency. How hard was it for you guys to go through the process of getting documents, FOIA, and other regulatory communications to make your case out of? I'm sure that was Herculean, wasn't it?
Yeah, so it's interesting that you raised that. So if folks are interested, if they go to causeofaction.org, they can learn more about this case. We have a really phenomenal video about our clients and their story. But for our organization, we've actually tried to litigate this issue before in the groundfish fishery, which is what is the subject of the Coda movie that
Mm-hmm.
we've both mentioned. And we've been fighting this issue since about 2014, 2015. And we have done, as our own organization, Freedom of Information Act investigation. And it has
Hmm.
been very difficult to piece together the sort of background connections between the agency and bureaucrats, some
Hmm.
of whom have had, after their government service, connections with the companies that now exist to provide
Shocked, shocked I am.
government monitoring services. Now, that the connections I have in mind, date back to the origination of this sort of requirement. So it's not as if it's a common thing, but there's definitely a lot of environmental groups who have their own policy
Mm.
agendas, and that's fair. People are allowed to; they have the ability to form groups and push their view, but it can become problematic when there's that sort of undue influence on the regulatory process, and when that isn't always known,
Hmm.
who might have had a role in influencing the rules. So I'm sure it doesn't come as a surprise to you that those sorts of connections might be in the background here.
Yeah. I feel like the police chief at Casablanca. Shocked I am to find out that gambling is going on. So, Ryan, what is your hope? What is your read now that the Supreme Court has agreed to hear this case? We were just talking about this in the opening of the program. What kind of precedential ruling? Certainly, you're hoping for a slam dunk, overturn the Chevron guidance. But what are your realistic expectations out of this after getting to this point, and the briefs filed? And now the Supreme Court says they're going to hear the case.
Yeah, that's an excellent question. And so when we filed our petition last fall, we offered two questions to the court that we wanted them to address. And the first was about the Magnuson-Stevens Act. That's the fisheries regulation law. And then the second was about overturning or limiting Chevron. The court this morning, when it granted the case, said it was only going to address the second question, meaning they don't want to really talk about the fishery law. They want to look at the big picture here of the administrative state
Hmm.
and the concept of deference and the viability of Chevron. Now, we're optimistic, not just because the court granted the case, but for a while now, the court has been, Chevron, at least at the Supreme Court, has been on shaky legs. The court hasn't been citing to it. It's been turning to major questions doctrine. Chevron's very much alive in the circuit courts. And so we are hopeful that we'll at least get very strong guidance from the Supreme Court about how Chevron should be used,
Hmm.
how it should be properly interpreted. Of course, our hope is that this entire scheme of deference will be will go away. That it really has no basis in the Constitution or in our our
Well,
order,
you know,
political order.
and Ryan, that's been a question that's dogged us both in our radio incarnation and back here on YouTube in the Afternoon Constitutional, is how reliant we've become on precedent. And that, all you have to do is get a good lawyer who can make a reasonable case that a ruling you made 40 years ago is about something completely different, has application today. And I think this goes down all the way through our courts. I know that's a bigger abstract than your particular case, but what do you think about that?
Well, I think so. One of the ways that you can judge the value of precedent, and when you're kind of looking into stare decisis and reliance, and whether the court
Hmm.
ought to disrupt something that's been around, in this case Chevron 1984, is how is it being applied by the courts? Is there a consistent interpretation? And with our case is a great example of why Chevron is such a mess, because the trial court came to one conclusion. The trial court said there's no ambiguity in the statute,
Hmm.
and even if there were, there's reasonableness. So obviously Chevron, the whole framework is the law ambiguous, and if it's not, is the agency's interpretation reasonable? And if it is, we're going to defer, right? And then the agency almost always wins. The trial court here said there's no ambiguity, and the agency wins. And then at the circuit court, the two of the three judges said, well, there's ambiguity, but the agency still wins. And the third said, no, there's no ambiguity, and the agency loses. And there's a similar lawsuit challenging this same regulation in New England, and the First Circuit issued a decision not a couple of weeks ago saying, well, I don't even Chevron applies, but I'm not going to tell you whether the statute is ambiguous or not, or whether it's reasonable or not. The agency wins. So here you have one, two, three, four different interpretations, four different ways of applying
Wow.
the same case. And then you have the Supreme Court that's not applying Chevron at all. It's going off into major questions doctrine world. And that's hugely problematic. And that's exactly the sort of situation where the Supreme Court needs to come in. And I mean, in our view, at the very least, it needs to say when a statute is silent. So here, the statute doesn't say anything about the authority to charge fishermen to pay for monitors to ride their boat. Doesn't say anything. The agency can't take that silence as an implicit delegation to basically do whatever it wants. But of course, our real dream is for this Chevron to go away altogether and for courts to go back to being arbiters of what the law says.
Mm-hmm.
That's the job of the federal court, is to tell us what the law is. It's not the job of the executive branch to legislate, which is effectively what happens often in these deference cases.
And again, help them out. It's a cause of action, and Ryan Mulvey is on with us. And I wanted to ask then, and maybe the final spot here. Yes, that is possible, and yes, that's what the courts are there for. But it's enormously expensive, where the process becomes the punishment. And I know that you've helped these fishermen out as as much as your contributions, donations have allowed to. But just the average Joe or Joanne radio show owner or TV station owner or car dealership owner, it costs them a lot to fight these fights.
Yeah. Oh, I think that is a fantastic point. And in this case, our clients are small business owners. They're family-owned businesses, and a lot of the regulated entities out there that suffer the most under burdensome regulation are small businesses that do not have the resources to be able to get a group like mine or a private firm to fight for them. Certainly beyond the trial court, to go all the way to the Supreme Court takes a lot of time and resources. So this case is a great way to highlight the impacts of regulation on these small entities that don't have a voice. And I mean, our hope is, the court steps in, and then if Congress takes its job seriously and legislates, then we'll have less of a, the court might have to force them into that position, right?
No, it's
we'll see. But I think this case also, in terms of low cost ways for people who are faced with dealing with regulation in their business lives, when a rule is coming out, comment on it. There's public comment processes for most rules that impact regulated entities. Send in a letter and tell the agency, look, this is, there's constitutional concerns, there's other statutory delegation concerns, there's cost concerns. People need to start fighting back against these administrative agencies, and hopefully that, combined with legal efforts and the right people in Congress deciding to do what the founders said Congress is supposed to do,
yes,
we can fight back the administrative state.
And just like our friends in the medical profession will tell you, catching some grievous illness early is the best way to beat it. And Ryan Mulvey, give the website again where people can help you guys out in this case and follow it along.
Sure. Cause of Action altogether, causeofaction.org. And the first thing you'll see on there is our client video and a page with all of the information about the case.
Well, I appreciate it, and thank you, sir, and you have a wonderful remainder of the afternoon, and congratulations on getting in front of the Supreme Court.
Thank you. Thank you so much for having me.
And as we opened it this morning, we're going to close it with this one. Thank you very much for allowing us into your streaming device, your smartphone, whatever it may be that you grab us into. Last one for you here. Of media people who have been married who have had 30 years pass since their wedding day. Very few of us can say we're still married to the same person, and she's amazing. She is everything that makes everything we do together possible. And so say happy birthday to Elaine Thomas if you see her. For me, we will reconvene here tomorrow at 3 or on the radio at 107.5 FM and 1260 AM and our free smartphone app, which you actually now have a link to this afternoon constitutional video on there as well. So again, thank you all for receiving all this, and until tomorrow, so long, and thanks for all the fish.